So today's a great day. I had a closing today. Woo-hoo, for my client. Woo-hoo, for me. All right. So the crazy thing is that it took 12 months to get here. Okay. So for a property to take that long, you're thinking, okay, there was all these things wrong with it. It was overpriced, bad negotiations, paperwork in and out of under contract, different buyers, none of the above. That property took 2.5 weeks to go under contract. It's literally been sitting in the pending status for 12 months. 12 of them. Okay. Here's what happened. He was selling a property that he inherited. Okay. When you are dealing with inherited properties, somebody had to have a will or somebody did not have a will. And depending on which one of those you get, depends on how it affects you when you try to go and sell, do refinancing, or anything like that for these properties. So that's what I want to talk about because it's a conversation that people have, but people really don't have this conversation. So let me break it down for you. When you pass away, you are either passing away in testate or testate. In testate means you passed away without a will. Testate means that you pass away with a will. In my client's situation, he inherited a property when his mother passed testate with a will. The catch is, depending on which state you're in, please consult an attorney because I'm not an attorney, I'm a real estate broker. But depending on what state you're in, there is a timeline as to when you must actually probate the will, or they don't even look at it. It's irrelevant. No one cares about it. It's almost like literally like a waste of time and money that your person put in to have a will. And we can't even fulfill it because no one probated the will during the required amount of time. Okay. So the year's worth of court dates that my client was going through was fighting the fact that they wanted to go by the law of descent, which I'll get to in a second, versus actually going by what's on the will. Okay. He did get his wish. We did end up going by what the will actually says, and that's why we were able to close. But it was a year's worth of court dates, attorney fees, filings, and all of the things, and a very amazing buyer and buyer's agent that was willing to stick out the year. Okay. Now, when you pass away without a will and you don't probate on time, then it's null and void, right? No one looks at it. Like I said, it's irrelevant. But when you pass away with a will and you probate on time, then whatever was in the will, that's what's going to happen. All is well. Everything is going to happen the way that it was written on that paper, no problem. If someone passes away intestate, meaning without a will, all hell can literally break loose. Okay. And it really just depends on so many different things. But there are two things that I specifically want to talk about. Community property. Community property is when a property is acquired during marriage. Okay. Doesn't matter who earned it, and it doesn't matter whose name is on the title. Community property is an asset or property that is acquired during marriage. Okay. If you acquired an asset or property before marriage, that's called separate property. It's whoever's it belonged to, period. There's nobody taking that from you. But if you go say, I do, you sign those magical papers, anything that you acquire after that, it is now community property. And we all know the saying, what's yours is mine, what's mine is yours. That's not always the case. Okay. So that's not always the case. And so many people rely on community property to get them through things when there was no will in place. That's why I want to talk about it. When someone passes away intestate and there's community property involved, if there are no children involved in that marriage, meaning the two spouses together have children, okay? However, they have them, whether they're adopted, it doesn't matter. If the two spouses together during the marriage have children and one passes away without a will intestate, it's community property and the children were inside the marriage. So you're good. All of the assets and property go to the surviving spouse, no question, right? If you have community property and you're still married to the person you have the community property with, and you had children outside of the marriage and someone passed away without a will, the person who passed away without a will, their community property share does not go to the surviving spouse because they have children outside the marriage. That community share gets split between however many children that late spouse has. Okay, so just in case you didn't track me, we got John and Jane Doe. John Doe and Jane Doe have been married for 20 years. They love each other. Everything is great. All right, perfect. Now, John, before he married Jane, was also married to Sally. They got a divorce, but John and Sally had 3 kids before he got the divorce and before he acquired new property with his new wife, Jane. Right. So that's how you got it's community property between Jane and John because Jane and John acquired the property during their marriage. He's divorced. He does have 3 children with Sally, but he's got community property. John does not have a will. So when John passed away in testate, John's community share did not go to his wife, Jane, his surviving spouse. It was split 3 ways between Sally's children. Period. Not Sally, but the children. The late spouse's children will split that property. I am dealing with at least 5 different cases right now, and I just closed maybe 2 or 3 that are dealing with these probate situations. And people are passing away these days with no will, and they have kids outside their marriage. They have kids inside their marriage. They're not actually married. They're common law married, and everything just falls apart when they get to that probate conversation or when they need to sell that asset, not just because they want the money, but because they literally can't afford it anymore because they don't have 2 incomes. And everything just blows up because there's no will or because there are children outside the marriage and the paperwork is not set up to where everything is split the way you want it split before you passed away. If you do not take care of your stuff, you're going to be on your family is going to be in a situation. I mean, they're going to be in a situation fighting over what the law says versus what you would actually want to happen when you pass away. All this to say, there's no reason why that closing should have taken any more than 10 to 14 days because it was a cash offer. Instead, it took 12 months because paperwork was not done and it wasn't in order and it was not probated on time. Okay, so again, my folks that are out there and I'm married and I don't have to, everything goes to my surviving spouse. That is not always the case. You need to make sure that your stuff is done in order. You have people that you can reach out to, realtors, you got title companies, attorneys are definitely going to be your number one conversation starter. Start with an attorney. What happens if I die today? What will happen with my properties? Who does it go to? What are the rules? What are the laws for your state? Get it figured out before it's too late.